Do police officers have the right to confiscate your guns just because someone else commits a crime while on your property? Well, that issue was just argued in front of the Sixth Circuit Court of Appeals, and this now sets up a critical Second Amendment challenge about the confiscation of your firearms. Now, really quick before we jump into this video, I want to thank everybody for supporting the channel. Thank you guys so much for everything you guys do. I hope you have an amazing new year. And then also, I just wanted to mention that if you want to support the channel for free, please consider subscribing to the channel. Also, click the bell icon, turn on all notifications, because that helps to ensure that you actually get these videos. Now, as I mentioned in the intro, in this video, we're going to be breaking down a really interesting and very important case that was recently heard in front of the Sixth Circuit Court of Appeals and will soon be ruled on by a federal court. This case involves whether or not the government can confiscate your firearms and keep them essentially forever just because someone else commits a crime while living or potentially on your property. In this case, a sheriff's department refused to return 14 firearms that they confiscated just because a tenant committed a crime while living on this property owner's land. The sheriff's office in this case continues to demand that the property owner actually provide evidence that those firearms are actually his. This confiscation was challenged in a lawsuit claiming that the sheriff's office was violating the takings clause, and also they were violating this man's Second Amendment rights. This issue has now made its way to the Sixth Circuit Court of Appeals, and actually, this case might result in a big win for the Second Amendment community. So let's break down what happened in this critical case. Now, the facts around this case are unfortunate and in many ways is actually frustrating. Mr. Novak owns what he claims is a hunting cabin, and it's in the state of Michigan. I believe it's kind of in rural Michigan somewhere. He rented out the cabin to Mr. Heinrich, who lives with his girlfriend, and they recently had a child. Now, this entire gun confiscation and seizure of the firearms resulted out of the fact that Mr. Heinrich, while as a tenant in this home, in this cabin, he got in a domestic dispute with his girlfriend over the crying child. Mr. Heinrich was annoyed with his girlfriend and the crying of the child, and he was frustrated that he believed his girlfriend was not doing what she needed to address the situation of the crying child. And unfortunately, as a result of this, Mr. Heinrich made a horrible decision and decided to grab one of the rifles and threatened his girlfriend while he had the rifle. He threatened his girlfriend and ultimately she left the cabin. Now, of course, the police were called and Mr. Heinrich was arrested for his conduct. After arresting Mr. Heinrich for felony aggravated domestic assault, the sheriff's deputies who came to the cabin decided to seize all 13 long guns and a pistol that were found at that house. Now, as a result of that arrest and the conviction, Mr. Heinrich is precluded and essentially banned forever from being able to possess firearms. Now, following the conviction of Mr. Heinrich, Mr. Novik, the property owner, called the sheriff's office and asked for the return of his confiscated firearms. He claimed that those were his personal firearms that he kept in that hunting cabin and that he used them potentially for when he hunted. And however, the sheriff's office refused to return all those firearms, and they claimed that they needed more proof that those guns actually belonged to Mr. Novak. Even though both Mr. Novak and Mr. Heinrich submitted sworn affidavits to the law enforcement officers and to the agency there that the firearms did in fact belong to Mr. Novak, the sheriff's office still refuses to return all of those items. Also in the challenge, the sheriff's office seems to claim, without expressly stating anywhere, but it was heavily implied, also was heavily implied during the oral arguments, that the sheriff's office believes that the firearms do actually belong to Mr. Heinrich, and that the two individuals here are in some ways lying so that they can get the guns returned and potentially get them to Mr. Heinrich, since he is barred from having firearms because of the domestic violence conviction. So they're claiming that these actually belong to Mr. Heinrich and that both individuals here are lying. Now, the only evidence submitted at all that they belong to Mr. Heinrich, the individual who has the domestic violence charge, is that he posted a single selfie online with him holding one of the rifles in his bedroom. So there's no other evidence that these actually belong to Mr. Heinrich. Now, in this case, Mr. Novak, the property owner, brought 2 challenges in state court, but each time the state court either said that it was not the proper process to get the return of these items, or that Mr. Novak was bringing a lawsuit against the improper defendant. Now, as a result of that, Mr. Novak decided to file a federal lawsuit in federal district court in Michigan, and he decided to file a lawsuit against the sheriff based on a violation of the Second Amendment and the takings clause. In this lawsuit, the sheriff and the government claims that this is an improper lawsuit, that it's barred by res judicata, which I'll explain a little bit later, but also they claim that there is no evidence that these actually belong to Mr. Novak and that he has not met his burden of affirmatively demonstrating that these firearms actually belong to him, and because of that, the sheriff's office can keep them essentially forever. In the lower court, there were cross motions for summary judgment, so both sides wanted to win the case outright before it moving to a full trial, but ultimately what ended up happening is the federal district court ruled in favor of the sheriff. They granted a motion for summary judgment in favor of the sheriff and dismissed the case with prejudice. As a result of that decision, Mr. Novak has now appealed up to the Sixth Circuit Court of Appeals, and he wants the Sixth Circuit to vacate and remand the case. Now, this lawsuit was just heard in front of a 3-judge panel in the Sixth Circuit. Oral arguments were held in mid-December, and it happened in front of judges Raymond Kethledge, which is a Bush appointee, Joanne Larson, who is a Trump appointee, and then Judge Andre Mathis, who is a Biden appointee. So from my initial impressions from listening to the arguments, I think that this is actually going to lean 2-1 in our favor of the Second Amendment, in favor of finding that this was a violation of the Takings Clause, and that Mr. Novak should have his firearms returned to him. Now, I mentioned that the sheriffs are arguing that this is a lawsuit barred by res judicata. Now, that's a fancy Latin term, which is a term that means as a matter judged. Now, this doctrine essentially prevents a party from relitigating any claim or issue that has already been litigated. And what is being argued here in the federal courts is that twice already state courts have addressed this issue and ruled against Mr. Novak, and because of that, this is barred at the federal side, so the federal challenge cannot move forward, and essentially it's barred. Now, in response to that, Mr. Novak argues that it's not the same issue, it's not the same defendants. When he brought lawsuits at the state court level, it was against the sheriff's department at large, but it was barred, according to the state court, that he could not bring that lawsuit. And so this federal lawsuit is against the sheriff individually. So it's a different defendant, it's a different lawsuit and different challenges. Now, like I mentioned, the judges seem to lean 2-1 in favor of Mr. Novak. In fact, one of the judges, which I believe was Judge Kethledge, says that he doesn't understand how this case actually ever made its way to the Sixth Circuit Court of Appeals. He almost had to stop himself from saying that, they have other major issues and other major cases. Not that this one's not important, but it seems so trivial that these firearms should have actually made their way back to Mr. Novak, and it's ridiculous that this case ever made its way to the Sixth Circuit. At one point, he also stated that he has bought a Mossberg 500 and other firearms, 20 years ago. He bought them in West Virginia. Now he's, I believe, in Michigan. And the judge here says he doesn't even know how he would be able to prove to someone like the sheriff that those firearms actually belong to him, other than him just saying, yes, I bought these in West Virginia. I've owned these for 20 years. The judge there believes that he has no other way to actually prove that, similar to Mr. Novak. A couple of the judges also asked multiple times what additional evidence the government wants of proof of ownership, but they could not provide any actual concrete evidence that would meet that type of burden. Now, Judge Joan Larson said that during the arguments, the home was owned by Mr. Novak and it was rented out to Mr. Heinrich, so the guns belonged to one of them. We know for sure they belong to either Mr. Novak or Mr. Heinrich. Now, we have sworn affidavits from both of them, and both of them are saying through those sworn affidavits that they belong to Mr. Novak. And she's almost saying that the burden is actually on the government to show that they are not. If they're going to try to keep them forever, the burden really should be on the government. And just the general sentiment seemed to be kind of pro-gun, pro in favor of Mr. Novak, and the understanding I got from the court was that they also believe this is ridiculous, that these were confiscated because of third-party activity in his hunting cabin that he rented out just because someone else did something. Now his firearms are confiscated forever and they won't be returned. And even though he is trying to show that they actually belong to him, the government is saying, no, we need more evidence. We need more evidence. You have to provide us more. We don't believe you. We're not going to give them to you. So now we're going to wait for the Sixth Circuit Court of Appeals to rule on this issue. But if I had to anticipate what's going to happen, I think this is going to be a 2-1 decision in favor of Mr. Novak. They're going to reverse what the district court said and send it back down to them for a proper decision. Now, the question then becomes whether or not the sheriff's department and the government here are then going to appeal this up to the Sixth Circuit level, take it en banc, and then potentially try to litigate this at a higher level, maybe even try to take it to the Supreme Court. So very interesting case, very interesting facts, concerning for a lot of people who own firearms. Firearms confiscation has become an even bigger issue now with things like red flag laws and other incidences now happening with federal agencies like the ATF and others, especially when it comes to other property being confiscated like braces, FRTs, other items like that, bump stocks. There's been a lot of things that are confiscated by federal agencies and local law enforcement, and a lot of times they refuse to actually return them to you. So this is one of those critical cases to cure that issue. Now, as we get more information, as things develop, I will let you guys know. But as always, thank you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.